Hello, everyone. This is Amy Hennon with the Maryland Volunteer Lawyer Service. We're really excited that you are joining us today for the first of our third Thursday noon webinar series. We're starting off with a bang with a really important one about the Fair Credit Reporting Act and Fair Debt Collection Practices, the Fair Debt Collection Practices Act. And fortunately for us, we've got Nathan with us today, who is going to let us know all we need to know about this topic. And so with that, I'm going to turn it over to Nathan.
Thanks, Amy. Good afternoon. My name is Nathan Baney, and a quick correction. This is most certainly is not going to be all you need to know about the Fair Credit Reporting Act and the Fair Debt Collection Act, but the purpose of this presentation is to really give you an overview of these two powerful consumer laws, and with the hope that with a lot of these consumer clients coming in, that we don't miss claims. A little bit about my history and kind of the genesis of this presentation. I was kind of a generalist practitioner. I've been practicing law for 10 years. I really didn't focus on consumer law until the last couple of years. I've taken a case now and then, but primarily I was doing general litigation, some consumer bankruptcy work, a lot of consumer bankruptcy work, and general consumer law. And I really started to focus on the Fair Debt Collection Practices Act and the Fair Credit Reporting Act a couple of years ago after a colleague of mine had some really successful cases, and we started seeing these cases everywhere. And I was at a bankruptcy bar conference a couple of weeks ago talking with Ellen Riddell about, all of the cases, thinking back through my career, all of the cases that I missed, particularly in the Fair Credit Reporting Act realm, just because I wasn't familiar with it. I didn't know the value of the cases, and I didn't know how to go about prosecuting one of those cases. And I told her, and what I'm telling you now is that if I knew back, in the first couple of years of my career what I know now, I would have been much more valuable for my clients, and my clients would have had much better results, because you don't want to leave any claims on the table. In the Fair Credit Reporting Act space in particular, a lot of times the clients that come, the claims that we end up getting out of the Fair Credit Reporting Act, the clients don't come to us originally with a credit claim. They come to us with something else. And after you wade through the initial part of the case, you're able to develop, and you'll see what I mean a little bit later when I say develop a Fair Credit Reporting Act case. Anyways, my contact information is on the front slide here. You'll have access to these slides. I believe you can download these slides, a PDF of these slides, through the software, the GoToWebinar software, and I encourage you to do that. And if you're not able to, don't hesitate to call me or email me, and I'll be glad to send you the slides. Because these slides generally are good to review, and I often do before I meet with clients, just to give myself a quick reminder of what's out there, what I'm looking for, and just to kind of keep these in your back pocket as you speak with clients. So I guess we'll get right into it. We'll first start talking about the Fair Credit Reporting Act, and there's a couple of case sites that I include in these slides. There's only a couple, two in fact, for the FCRA. They're both Fourth Circuit opinions, but you'll find those Fourth Circuit opinions cited in every FCRA opinion in the Fourth Circuit. They are seminal cases, and they're not long opinions, 12 to 15 pages, but they're definitely worth a read if and when you have the opportunity. But for those of you that don't know, the FCRA was enacted to ensure fair and accurate credit reporting to promote efficiency in the banking system and protect consumer privacy. The Fourth Circuit in the Saunders versus Branch Banking and Trust case identified that the FCRA requires consumer reporting agencies, CRAs, and I'll be using CRAs, that acronym, quite a bit in the presentation. It requires the CRAs to follow procedures in reporting consumer credit information that both meet the needs of the consumer and are fair and equitable to the consumer. It's a very consumer-friendly statute. The CRAs and the furnishers, one of the reasons that these cases exist in the frequency that they do is the furnishers and the CRAs have a very different idea about what their duties are under the FCRA. And we'll get into that a little bit later, but the FCRA imposes duties on furnishers by prohibiting any person from furnishing information it knows is inaccurate, and the furniture must correct and update information provided so that it is complete and accurate. The FCRA, if you were just to look at it in the code book, is a somewhat intimidating statutory scheme to kind of wade through. We'll break that down a little bit more, give you the important highlights, kind of where the most frequent claims are, and what you're looking for in those claims. And if you're actually going to prosecute a claim under the FCRA, you have to have more information than what these slides are really conveying. And I encourage all of you to, if you have an interest in this area of law, join the National Association of Consumer Advocates. If you're not already, get the treatises from the NCLC. Those are great resources, and attend some conferences. But I encourage you, if you are going to practice in this area, to really dive in and get more information than what you're going to get out of these slides. But if you are able to identify some potential claims in these slides and either co-counsel with an FCRA attorney or refer these out to an FCRA attorney, even if it's not me, you're going to be doing a huge favor for your clients. The FCRA applies to consumer reports. Consumer reports, as you can see, any communication of any information bearing on a consumer's creditworthiness, character, general reputation, personal characteristics, used or collected for the purpose of serving as a factor in establishing the consumer's eligibility for employment purposes, credit, insurance, family household purposes. What this means in practice is that consumer reports include credit reports. Those are the typical ones. The three biggest credit reports, as you pretty much all know, TransUnion, Experian, Equifax, are the three big nationwide CRAs. But also there's a lot of smaller companies that provide background screening checks, that do specific things for bad check writing history, insurance underwriting reports, and specifically tenant screening, residential lease history. Those are all considered consumer reports. Throughout the most of this presentation, I'll use consumer report and credit report interchangeably, but as a legal matter, consumer report is a much broader term than simply a credit report. But in 95% of the cases when we talk about a consumer report, we're usually referring to one of the big three credit reports. Who does the FCRA apply to? And I've used some of these names already, credit reporting agencies. Again, the big three, TransUnion, Experian, Equifax. There's a number of specialty credit reporting or consumer reporting agencies. Like I said, background screening companies for employment, residential leases, etc. Furnishers. Now, these are the companies that furnish the information that goes on the credit reports. They provide the information to the CRAs, primarily banks, credit card companies, mortgage companies, debt collectors, utilities. generally that's who you're talking about with furnishers. Users are generally, a lot of the companies that have contracts with the CRAs to furnish the information are also users of that information. So a bank, et cetera, when you apply for credit, anyone who pulls your credit report is considered a user. Now, it's usually these same entities, but it also includes potential employers who wouldn't be furnishers of information for the most part, but they do use that information as background checks and whatnot. So when you're starting to consider any credit case, you have to start by accessing your client's credit report. So how do we go about doing that? Now, pretty much not all, but a lot of potential clients, when I say, do you have a copy of your credit report, they'll come to me with a tri-merge report from, for example, Credit Karma. A tri-merge report is simply a company that pulls information from the 3 credit bureaus and aggregates them into one report. There's a lot of information that you can get from those. The problem with those is they don't have all the information. And so if you're gonna, and you'll see, and I'll talk a little bit about more of it later when we go through some of the actual claims, some of the claims you're not gonna be able to find on a tri-merge report. And so getting the reports from the source is important. The web address, the big 3 have, I guess, started a service where you're allowed to download a free copy of your credit report once per year from www.annualcreditreport.com. And you can do that by mail to the 3 addresses I have on this slide. If your client has already obtained their report once in the last year, they can also get it by paying $11.50. And that report will contain the consumer's file at the time of the request. And so that's always the first hurdle. If the credit reporting agencies, well, when you go to annualcreditreport.com, if you haven't done it before, what your client will have to do is answer some questions about their credit history. And if they get those questions wrong, generally they'll have to order it by mail. The bad part, if there actually is an inaccuracy on your client's credit report, or there's a mixed file or something, they're not going to know all the information on their credit report. And so just because they can't access their report through www.annualcreditreport.com isn't a bad thing necessarily, because that means there's more likely that there's a claim on there. So don't give up if your client can't access it through the website, because even though it takes a little bit longer, the fact that they have to order it through the mail is an indication that there might be something on there that either your client doesn't know about and is potentially inaccurate, or your client just makes a mistake. I don't know if you've ever had a client make a mistake before, but certainly it happens. All right, so we have our client's file. We finally have their credit reports. What are we looking for? So here's some typical fact patterns that give rise to claims, and these are not exclusive of each other. For example, internally inconsistent data. And what I mean by that is, if you have a credit line, first of all, if there's 2 different social security numbers contained on the report anywhere, that's internally inconsistent data. Another example would be, so your client is 20 years old, but they have a trade line on there that they say isn't theirs, and the trade line says that it was opened 6 years ago. Well, that's going to be internally inconsistent because your client couldn't possibly have had a credit account before their 18th birthday. So that's going to be that. Those are generally big red flags and potentially indicate that there's been some sort of ID theft, that there's been some sort of mixed file. And when I say mixed file, I mean that the credit reporting agency itself mixed up the data of 2 different people, either because their social security numbers were close enough, or their names, the spelling of their names was close enough. Those are good, really good cases, because the CRAs are at fault, are pretty clearly at fault in those particular cases. Other types of patterns giving rise to claims: if there's multiple entries on the credit report of the same account, if your client's disputed a particular trade line on their credit report, and the furnisher or the credit reporting agency refuses to note that dispute, that's a big red flag. If the credit report contains obsolete data. Except for bankruptcies, pretty much everything on the credit report should fall off timeout after 7 years. Bankruptcies will stay on the credit report for 10 years. Another thing that has come up is, especially in the context of debt collectors, is re-aged accounts. So if you have a Capital One account and Capital One sells that account, that defaulted account to Santander, and Santander's doing the collection on that account, the trade line will fall off after 7 years. But when Capital One sells that, Santander restarts that clock and says that, well, they got the account only 4 years into that, and they renote that they have the original default date as the date that they got it. That's essentially re-aging that account, and that's not permitted because that account will live on the credit report much longer than that 7 years. Sometimes you'll see re-aged accounts when you dispute a trade line and the debt collector has to take a look at that account. They'll restart that clock every time you file a dispute, and so that'll give rise to a claim right there. You also see a lot of inaccuracies as to payment histories, ID theft, impermissible access. So if someone does a hard pull of your credit, hard pull or soft pull of your credit, and they don't have a permissible purpose, that's a violation. Each one of those pulls is a violation of the FCRA. Ownership disputes and joint users. So if there's a dispute about who's the guarantor on the account, whether or not someone's an authorized user or a signatory on the account, that comes up and comes up fairly frequently. So we're going to go through the individual typical claims now that you'll actually see, and kind of give you an idea of what what you're looking for each of those claims and how you go about developing those claims. All right, so these are the frequent claims against credit reporting agencies, and I've got an asterisk next to 2 of those, and those are going to be the most common, 1681EB and 1681I. And while we're looking at this, this is a good time to note the structure of the statute itself. Unlike most statutes, if you've never looked at the Fair Credit Reporting Act before, the entire act is put under 15 U.S.C. 1681. I don't mean it starts at 15 U.S.C. 1681. All of the statutes are under 1681. So 1681E, 1681I, 1681K, those are all different statutes under 1681. There's not a 1682. And so that, if you're not familiar with that structure, can be a little confusing at first and a little off-putting if you're not used to it. But such as it is, this is what we have to work with. And so looking at these claims against credit reporting agencies, as I said, the 2 most common, and you'll see them in 95% of FCRA opinions, will be these EB and I claims, the maximum possible accuracy and the reinvestigation of disputed info. You'll also see 1681K, that deals with public record information being provided for employment purposes. 1681C, that's essentially excluding certain info from the report. So that's when things are supposed to be timed off after 7 to 10 years. That is where that would come into. 1681C2 is a block identity theft info when they get a report of certain trade lines or certain consumers being a victim of identity theft, and that includes the identity theft affidavit, the police report, and the specific information. The CRA has to immediately block that information from the credit report while the investigation plays out. And 1681G, that's to provide the report when the consumer asks. There's not a private right of action to enforce 1681G, but just as an FYI, when you are trying to obtain the reports, that is the duty the CRAs have under the FCRA to provide the reports to the consumers. For claims against furnishers, and again, the big one, 1681 S2B, that's the asterisk next to it. This is going to be in pretty much every case against the furnisher, and they have a duty to conduct a reasonable investigation upon receiving notice of dispute from the CRA. And I'm going to go through these individual sections a little bit more and flush them out a little bit and give you some examples of when these have come up, but this is kind of just a quick reference for the most popular, I guess popular is a little bit of a misnomer, but the most often used provisions under the FCRA. Now, against the users, these are all under 1681B. These are the people that access the credit information. The 1681BF is just going to be the impermissible access, and this 1681B is a tough read, but we'll get into it a little bit more later on. I can try and flush it out a little bit, but essentially they have to have a legitimate business purpose for accessing that information, and the courts and the statute itself really flushes out what that means. Employers have duties under BB2 and BB3. They have a duty to provide a clear and conspicuous disclosure on a separate document and authorized in writing, get authorization in writing to run a background check on you. And then they have a duty, and this is where they oftentimes cut corners. They have a duty to provide you a copy of the report with a description of your rights if any adverse action is taken in whole or in part based on that report. So moving on, we're going to jump into the investigation and the reinvestigation causes of action against the CRAs and the furnishers. And as I mentioned, these are two of the asterisk statutory provisions that you'll see most of the time, because when you see something wrong in the credit report, pretty much always you're going to want to file a dispute. And that dispute must be sent to the CRA. If you see, if Capital One is reporting something incorrectly on your credit report, sending a dispute to Capital One directly doesn't trigger any liability under the Fair Credit Reporting Act. All disputes must be sent to the credit reporting agencies, the consumer reporting agencies, for there to be any liability triggered under 1681I or 1681S2B. The case will be thrown out if you just send the dispute to the furnisher. Even if you only intend to pursue the furnisher legally, that dispute must go through the CRA, and you'll see countless opinions nationwide where cases are thrown out because either attorneys or pro ses didn't understand that simple premise. So when you send this dispute or help your clients prepare these disputes, what do you include in them? Well, if something's incorrect on their credit report, basically explaining why the item is incorrect. If you can send proof, as in bank statements that show different payment histories, or in the case of an identity theft, if you want to challenge the account altogether, usually you send the police report. You also maybe you'll send writing samples or samples of the client's signature for the furnisher to compare with the credit application. Anything you can send to disprove, because what often happens when the CRA receives the information, they'll have a duty to reinvestigate, which we'll see right here. The CRA, once they receive a dispute, they have a responsibility to conduct a reasonable investigation of any information disputed, forward that dispute to the furnisher within 5 days, complete that investigation within 30 days, delete and modify information that is found to be inaccurate, incomplete, or cannot be verified, and send the consumer the results of the reinvestigation. The CRAs clearly have a significant duty here, and the Third Circuit said the grave responsibility imposed under 1681I must consist of something more than merely parroting information received from other sources. And that gives you a hint as to what the CRAs believe their responsibility is once they receive a dispute. The CRAs don't see themselves as an investigative body. They see themselves as an aggregator of information. They put information on your credit report that they receive from the furnisher. When they get the dispute, they send those disputes to the furnishers, and the furnishers respond, and the credit reporting agencies just report what the furnishers respond with. Rare is the case, and I haven't seen it, where the CRA takes its own initiative to actually investigate what has been received by the consumer and overruled essentially what has been provided to it by the furnisher. And that, for the amount of disputes that a CRAs receive, you have to consider what their business is. They get paid by the furnishers. All these furnishers have subscriptions in one way or another to the CRAs. The furnishers are the ones paying the CRAs. And so for a CRA to override what the furnisher is telling it is a pretty big step. And for the most part, they don't get punished for that, because for the most part, consumers don't bring suits under the FCRA. It's very rare, given the amount of the disputes versus the amount of actual lawsuits filed, which is why this is an area of law that there's a lot of work under the FCRA if you know how to find it, which is hopefully what this seminar will help you do, or at least identify where the potential cases are. The furnishers have a similar duty to investigate when they receive a dispute from the CRA. And again, they must receive it from the CRA, not the consumer. So their investigation must be reasonable. They must review all relevant information sent by the CRA, and they must complete their investigation within 30 days. Then they must report their results to the CRA, and if there's anything incomplete, inaccurate, or cannot be verified, the furnisher must delete or modify the reporting as appropriate. So they also must note the account is disputed to the CRA. And this seems like a little thing. Whoops, I'm going to go backwards. This seems like a little thing, but if an account is disputed on the CRA, it doesn't count. It still shows up on the credit report, but it's used differently. It's weighted differently to calculate the credit score. And so the failure of a furnisher to mark an account as disputed has ramifications. And so that's why the FCRA requires it for these disputes. So what is a proper investigation? And you'll note that I have added a case site on this slide, Johnson versus MBNA Bank. This is a Fourth Circuit 2003 opinion. And in this particular case, And I had a case that was actually very similar to this. Johnson was listed on a credit report as a guarantor, as a co-obligor on a credit card. Well, he claimed that that's not true. He was only an authorized user, and in fact, he never really even used this card. The Fourth Circuit decided in Johnson's favor, stating that 1681 S2B requires creditors, after receiving notice of a consumer dispute, to conduct a reasonable investigation of the records and determine whether the disputed information can be verified. And in this case, MBNA couldn't find the original application on this account. And think about how often this happens, where the creditor can't produce the original contract. In this particular case, MBNA could not find the application, and the Fourth Circuit said that under the FCRA, because it could not verify the account, it should have modified the trade line on the credit report by either modifying it or by deleting it. And the Fourth Circuit stated a jury could reasonably conclude that if MBNA agents had investigated the matter further and determined that MBNA no longer had the application, they could have at least informed the credit reporting agencies that MBNA could not conclusively verify that Johnson was a co-obligor. So I've used that language. Well, I use that language in pretty much every case where I've filed an FCRA case after dispute and then the furnisher couldn't come up with the original application or original credit contract, which, as you can imagine, happens a lot. So the reason why there's liability oftentimes for the furnishers also goes to how the furnishers themselves go about investigating these disputes. For the most part, they will offshore this to India. They'll have an individual sitting in front of a computer who will receive the electronic dispute, will look at the computer system to verify that the information on the original credit report matches what they have in their system, and then verify based on the information in their system. But think about how ridiculous that is, because the information is originally reported to the credit reporting agencies by the computers in the furnisher's system. And so then they get a dispute, and then they re-verify that information based on the very same information that was in the system that provided the original information to the CRA. So frequently, the furnishers fail to conduct any type of reasonable investigation. Further, the Fourth Circuit has defined what is considered inaccurate information. And inaccurate information on a person's credit report is considered inaccurate when it is patently incorrect or when it is misleading in such a way and to such an extent that it can be expected to have an adverse impact. So you can have information on an individual's credit report that is technically legally accurate, but it creates a false impression to such an extent that it could have an adverse effect and therefore be considered inaccurate for the purposes of the FCRA. And that's huge, because you don't have to argue then over the technicalities of whether or not something's being accurately reported. So, for example, I used this in a case when it was a situation where my client, and this is all public record information, my client got divorced from his then wife, and the wife in their settlement agreement agreed to take over the mortgage. Now, just because, as most of you know, just because she took over the mortgage in their divorce settlement doesn't absolve him of legal responsibility to the mortgagor. But she ended up filing bankruptcy, letting the house go to foreclosure. And it was reporting as a foreclosure on his credit report. And in our dispute, all we asked is that the credit bureau note on the account and the furniture note on the account that his ex-wife had assumed responsibility for this note, and that and it was our argument that this doesn't reflect poorly on his. It shouldn't reflect poorly on his credit worthiness because he didn't assume responsibility for that note in their settlements. Well, obviously that didn't get far when we were just disputing it, but when we filed the lawsuit, it certainly did, and we ended up getting that taken care of. And what you'll find when we talk about case results under the FCRA, pretty much every settlement is going to be confidential. And so when we discuss what happens to these cases, sometimes I won't be able to give you as full of information as I would like, but I do bring up the substance of the claims and note that the cases were settled. Of course, the CRAs and the furnishers didn't admit any liability in those settlements, but you know how that goes. The other most common claim is a 1681EB, and this is a claim against the credit reporting agencies. They have a responsibility to have procedures in place to assure the maximum possible accuracy of their reports. So under a 1681EB, technically you don't need to file a dispute before you file a 1681EB claim. Now, once the courts have decided, and there's case law out there, that once you file a dispute, what becomes reasonable under this maximum possible accuracy statute shifts more in favor of the consumer, because now the CRA is on notice that there is a potential problem with this report. The best cases for the maximum possible accuracy involve those which we discussed earlier that have some sort of blatant inconsistency in the reporting itself. So again, different dates of births, accounts open when the client was a minor, multiple social security numbers, multiple names that the client doesn't recognize. Those are going to be potential 1681EB cases. I've also had 1681EB cases where the credit reporting agency, a consumer reporting agency, falsely reports or misreports judgments on the client's account. Or there's a tenant screening case where the tenant had an old judgment against him, but the CRA was reporting it as an eviction when it wasn't an eviction, and the consumer lost the opportunity to rent several different places because of this false reporting. That's going to be a 1681EB claim. The elements of a 1681EB claim: the report contains inaccurate information. We discussed earlier what inaccurate information means, that the CRA did not follow reasonable procedures to assure maximum possible accuracy. And that gives a little hint as to what these cases generally entail, and why they are so complicated is because oftentimes you're arguing about what is or isn't a reasonable internal procedure of a consumer reporting agency. And so that is a unique part about this type of consumer law that makes it can make it really tricky to prosecute these cases, is because you often get into very technical reporting, especially when you're dealing with the big three CRAs. Finally, under a 1681EB claim, there has to be damages. And this came out of a very recent Maryland case where the judge said there must be publication, and that it can't be considered a consumer report if it's not reporting to anybody. So what constitutes a reasonable procedure? The courts have said that a reasonable procedure, they must take into account a balancing test. They've got to weigh the costs of verifying the information versus the possible harm of reporting inaccurate information. What you'll read about in a lot of these cases is, okay, what's the cost of verifying the information? So that gets into how much time would have had to have been required versus how much time was actually spent. And what you'll find out is that some of these CRAs, when they're verifying information on these consumer reports, it averages out to costing them about 6 cents a dispute, and that's because you'll have someone sitting in front of a computer terminal and processing as many of these as possible, because they get their compensation based on how many disputes they can get through, or how often they can get through and verify the information. When you're talking about damages in these types of cases, and I'll talk a little bit about this more in a little bit, but damages oftentimes in the FCRA case, you'll have the increased cost of credit, denials of credit. It might cost them housing, it might cost them a job. Those are the most obvious types of damages that you'll be dealing with. But you'll also have emotional distress, the stress and worry of going through and disputing this, not being able to fix it. A lot of times you'll have sleepless nights. People will go on antidepressants, and you'll have family members that will be able to attest to their moodiness. Maybe their job performance goes down. And you'll see that in lots of consumer cases where the damages are often hard to calculate, but they mean a lot to the individual people involved. And they are, just because a lot of other, sometimes the opposing counsel will have trouble seeing the damages of your clients, that doesn't mean that your client can't. And each of these cases is very important to them, because they've lived with the stress. Sometimes they've disputed 5, 10 times and feel helpless in trying to get these things fixed. Now, I already mentioned the employment-related claims. This is where it kind of fleshes it out a little bit more. You'll have this in the slides if you download them, and I encourage you to do that and keep them for quick reference if you need to look for kind of what claims you might potentially have. And again, this gets to the 1681C, the information that should be excluded from reports. I mentioned that pretty much everything except for the bankruptcy cases needs to fall off the reports after 7 years. And then when the CRA gets information regarding identity theft, it has to take specific steps if it receives this information: the proof of identity, the identity theft report, statement by the consumer. And when you're verifying your identity, I usually send a copy of the Social Security card, a copy of the driver's license, and a utility bill with the current address of the client. And I also send those 3 things when I'm attempting to obtain a report through the mail. You'll see that if you don't send those things, a lot of times you won't be able to get a copy of the report. The impermissible access cases, this breaks this down a little bit further. It can be, I recommend that you look at the statute itself, but this breaks it down a little bit more as far as legitimate business need. It must be in connection with a business transaction which is initiated by the consumer, or to review a current account with the consumer to determine whether the consumer continues to meet the terms of the account. Good cases in impermissible access, you'll see a lot of times after a bankruptcy. You'll have a person that has multiple credit accounts, and the creditor is used to pulling the account just to check the consumer's creditworthiness. For example, Capital One, maybe they'll pull it 3 times a year. And then after the bankruptcy, they continue to do so, even though the account no longer is open or on file with the creditor. And so each of those pulls is an impermissible pull, and to which liability attaches under the FCRA. Statute of limitations under the FCRA, 2 years after the violation itself or 2 years after the discovery of the violation. In the cases where you're the 1681I or 1681-2, where we're talking about the investigation, reinvestigation, the claim actually doesn't come to fruition until after the dispute. And so that's when the 2 years is going to start. That's actually when both the 2 years and the 5 years start. But really, you've got 2 years after they fail to follow reasonable procedures to fix the disputed information. For damages, we've got two different provisions, 1681O and 1681N. Any person who, let's see here. All right, so any person who is negligent in failing to comply with the FCRA is liable for actual damages, attorney's fees, and costs. In addition, if the violation is willful, you can also recover punitive damages and statutory damages. Examples of actual damages: denial of credit, increased cost of credit, damage to reputation, loss of financial independence, invasion of privacy, emotional distress, embarrassment, frustration, physical symptoms. If you've done consumer law, you know headache, loss of sleep, loss of crying, interference with work, loss of security clearance, delayed start dates, inconvenience, interference with normal and usual activities. For example, the time spent trying to fix the errors, review the reports, fix the credit. These damages are real, and they significantly affect the quality of life of your potential clients. This is my favorite real-life example of a credit case and the development of a credit case. This is Carrie Arthur versus BOA. This is a Virginia case. Carrie Arthur lost her job. She asked for an extension with her mortgager to make the payments. They suggested she apply for a modification. Now, keep in mind that she hasn't missed a payment yet. They advised her to start making the trial period payments. And again, many of you who've done any type of real estate or a mortgage, any of these HAMP cases, mortgage cases, knows this fact pattern. So during the trial period, they make the trial period payments instead of the normal payments. The client makes the payments, follows the bank's instructions. Months later, she's told her application is denied, that the loan is in serious default, and they need a bunch of money to avoid foreclosure. In addition, the bank's reporting her over 180 days delinquent on all her credit reports. Her credit's destroyed. So what happened in the case of Carrie Arthur? She got involved in a nationwide class action just for these modification violations. And that case was grinding along up, I think it was up in a court in Boston. But she found a credit reporting attorney and talked to them down here in Virginia. And the credit reporting attorney started disputing the negative reporting of this, and providing all, thankfully, this client was one of those that kept every single piece of paper, had all the email correspondence, and had meticulous notes with each phone call. They were sending all of that in their disputes to the CRAs, and they eventually decided to sever the case from the class action because it was moving so slowly up in Boston. And they brought in a 1681 S2B claim against Bank of America, in addition to the RESPA claims and the breach of contract. Now, they didn't have a 1681 S2B claim originally. All they had was the RESPA cases and the breach of contract. They developed the FCRA claim based on Bank of America's duties under the FCRA. Now, what happened, in addition to the cases against Bank of America, they also had 1681I claims now against the CRAs who were simply parroting what Bank of America was reporting them, despite all the information provided by the client. Now, this case was handled by one of my by an attorney in my firm, and the results of the settlement are confidential. But it's been reported that the client obtained the property free and clear. The newspaper knows this, got this from the land records, and so the only way that they would have gotten that would have been in their settlement with Bank of America. So they got their property free and clear of mortgage based on the case which they added the credit reporting claim to. In addition, they got cash settlements, probably, from each of the CRAs plus trade line deletions. And again, I have no idea what the terms of these settlements actually were, but this is my guess as to what they end up getting. So they developed a claim against an FCRA claim against Bank of America, and then they developed claims against the CRAs for not completing their duties under the FCRA. In addition, I mentioned other real-life examples is when you have spouses divide up the responsibility for debt, and you have, am I an obligor, am I an authorized user situation, and a lot of times banks don't have the information. They can't prove it one way or the other, whether or not an individual is an obligor on the account. And if they can't do it, that means they can't verify it. And if they can't verify it, they've got to modify the trade line. And again, I mentioned the bankruptcy issue with the impermissible access. And so those are kind of ways that these FCRA cases are developed. Also know you have a lot of times I've had a number of cases where you have the default judgment entered against the client, and they come to you saying they have no idea where this judgment came from, they weren't served with anything. So you get the default judgment set aside, and then later on you dispute the credit reporting of that default judgment. And if the credit report, if the CRAs don't fix it, or the creditor plaintiff doesn't fix the reporting of it, you'll have an FCRA claim against the CRAs and the furnisher of the information. So we are 50 minutes into this, and we don't have a whole lot of time left. And so I want to jump right into the Fair Debt Collection Practices Act. These slides I developed straight from an outline that I use when I evaluate FTCPA claims. Again, it's very basic understanding of the FTCPA. The FTCPA prohibits false, deceptive, misleading, harassing, abusive, and offensive conduct during the collection of consumer debts. It was enacted in 1978 to prevent personal bankruptcy, marital instability, loss of employment, and invasion of personal privacy. There was recently a Supreme Court opinion that came down that affects the FTCPA, and it affects who's considered a debt collector under the FTCPA. And that case was Santander, is how it's referred to. I don't have the specific site. I guess I don't, for some reason, don't have the specific site at my fingertips here. But that case says that a Santander was not a debt collector for the purposes of the FTCPA. And that case said that it doesn't apply to a debt buyer whose principal purpose is not the collection of debts. Santander is a giant banking conglomerate that does far more than just consumer debt collection, as it appears it does primarily in the U.S. I believe it's a Spanish bank so its principal source of business is not the collection of debts. And very specifically, that Santander had purchased the debt itself. And so the Supreme Court was only looking at the second definition of debt collector as one who regularly collects or attempts to collect the debt owed another. In that particular case, Santander purchased the debt, and so it couldn't have fallen under that second definition because it now was the owner of the debt. And the parties agreed that the first part of the definition didn't apply because it wasn't the principal purpose of Santander to collect the debts because, like I said, it's an international banking conglomerate. Santander's a rare case, and there has been other debt buyers that have tried to cite that case to try and have cases kicked out already, and I'm sure you'll see it if you sue any one of them, but a lot of times their principal purpose of their companies is to actually collect the debts, and so they do, they'll fall under that first definition. Anyways, moving on, what does the FTCPA prohibit? Here's a brief rundown of the types of communications that's prohibited. They're not allowed to discuss the debt with a third party. There's an exception for a person's spouse, and there's a couple of other exceptions, but for the most part, they can only contact a third party for the purpose of obtaining location information. And in that context, they can't disclose the existence of the debt or the purpose of the phone call. There's time restrictions on when it's reasonable to call, not before 8, not after 9. And there's a few others on here that you can see. And again, like I said, this is a brief outline to kind of give you an idea of what to look for. It also prevents the abuse and harassment. And what is considered abuse and harassment? Well, the threat of violence, using obscene or profane language, cannot publish lists of the debtors or advertise debts. That includes blacklisting, and they cannot place calls to the consumer without meaningful disclosure of the debt collector's identity. The debt collector is not supposed to try and trick the individual into paying. And an important note about the FTCPA, it doesn't matter whether or not the consumer actually owes the debt. Let's say for example the consumer does actually owe everything that the debt collector says they owe. Well, they still have protections under the FTCPA. Don't let whether or not they owe the debt cloud whether or not the collector has liability under the FTCPA. The collectors are prohibited from using false, deceptive, or misleading tactics. They can't falsely represent themselves as an attorney. They can't falsely represent the amount or the legal status of the debt. They can't threaten a suit or garnishment without the legal ability to do so. I had a case like this where the debt collector kept telling the debtor that he was going to take her car when there was actually no ability for him to do so. The car was underwater, and plus this was in a case in Virginia where they had a certain amount of exemption and equity of the vehicle, and so he had actually no ability to actually do that. And so the threatening to do that was a violation of the FTCPA. Also threatening a lawsuit on a time-barred debt. That is an interesting, so that was in my original outline. Supreme Court has since come down and said that it's not a violation of the FTCPA for a collector to file a claim in a bankruptcy case based on a time-barred debt. So I would be curious to know if that will affect that ability, because obviously statute of limitations is an affirmative defense. So that's an interesting area of question of law that I personally have as to whether or not that will continue. Moving forward, the debt collector can't use unfair or unconscionable acts. Collecting any amounts not authorized by the agreement, miscalculating the interest, miscalculating attorney's fees, soliciting or accepting a post-dated check without providing the required notice of 3 days that they intend to deposit that check, threatening criminal prosecution based on that post-dated check. That's all considered unfair or unconscionable under the FTCPA. So there's also another subset of cases about what type of notice is required under the FTCPA. And here, the courts use the least sophisticated consumer standard in determining whether or not the communications contain these required notices. The initial communication must state, either oral or written, that this communication is from a debt collector, and in an attempt to collect a debt, any information obtained will be used for that purpose. And then they have different language for subsequent communications. Within 5 days of the initial communication, whether or not that initial communication is oral or written, the debt collector must provide in writing a notice of the amount of the debt, the name of the creditor owed, the right to dispute the validity of the debt within 30 days, the name and address of the original creditor, and that if that information is disputed by the consumer within 30 days, the collector will provide verification of the debt. So potential damages under the FDCPA, actual damages including emotional distress, statutory damages of up to $1,000 per violation, the cost of litigation, and reasonable attorney's fees. A lot of the similar types of damages, except, of course, the denial of credit, and as the FTCPA, you have loss of reputation, loss of financial independence, invasion of privacy, emotional distress, embarrassment, frustration, anxiety. And if you have a person getting these calls and a debt collector who's violating the FTCPA in these ways, your clients will have a lot of anxiety and frustration. And a lot of times they'll experience some of the physical symptoms as well, the headache, the loss of sleep, the crying, etc. So I know this is brief. This is a very brief summary of these types of claims. I hope that this presentation will help you identify some of these claims on your own. And at the very least, if you aren't able or willing or need some help, I hope that you'll reach out to a consumer attorney. You can always reach out to me. If I can't help, I'll certainly be able to put you in touch with an attorney who will be able to help. Some of these claims, especially under the FCRA, they're complicated, they're time consuming. And even if you're simply going to, if you do want to stay involved in the case, I recommend co-counseling with someone who has some experience, and you'll learn a lot. And most, as many of you know who've taken consumer claims before, it's a small bar. A lot of the attorneys are very, very kind and willing to help and willing to donate their time in advance of the consumer's causes. But I know that I'm speaking I don't need to tell this crowd that. I don't believe that for a second that you have any different experience when it comes to these consumer types of cases. So I guess if I'm always happy to take any questions. My contact information is on the slide. Amy wanted me to talk to you about if you are interested in taking consumer cases to review for these possible issues, to please reach out to her and she'll make sure you get on that list. And she'll put you in contact, help put you in contact with someone who will take a look at these cases if you have a potential issue that you don't know what to do with. So again, I hope everyone got something out of this. And if nothing else, please keep the slides, and hopefully they'll help you when looking at some of these cases. I want to thank the MBLS for allowing me to put this on. It's been fun putting it together, and like I said, I just hope that at least somebody got something out of it. Thank you.
Thank you so much, Nathan. Hi, everyone. This is Ellen Riedel with the Maryland Volunteer Lawyers Service. I just want to thank everyone for attending the webinar today, and especially thank Nathan for taking the time to put this presentation together and to give us this really wonderfully useful information. We hope that you all got a lot out of this. And again, if you have any questions or you think you may have a client with these issues, please contact us or contact Nathan. We're happy to get you in touch with someone who can co-counsel or do these cases with you. Just one quick note, if you are helping an MBLS client in a pro bono case, Due to our funding, any affirmative claims like these would need to be either on a pro bono basis if it's included within that MVLS case that was referred to you, or it needs to be separated out from the defense case. If you're helping someone with a debt collection defense case, it would need to be separated out if you want to collect the legal fees yourself. So if you have any questions about those types of issues, if you're helping an MVLS client, please feel free to reach out to Amy or myself, and we're happy to kind of wade through those issues with you. So thank you everyone for coming. If you don't get a copy of the handout, let us know. We'll send one out to you, and I hope everyone has a great afternoon.